Big news for employers, foreign professionals, universities, and the immigration community. A federal judge has just struck down the controversial 100K H-1B visa fee that was imposed under a 2025 presidential proclamation. Does this mean the fee is gone forever? Can employers immediately file H-1B petitions without paying the extra 100K fee? And could the government bring the fee back through an appeal? Hi, I'm Muhammad Amir. I'm an immigration attorney and founder of Amir Law Firm. Today, we will break down exactly what happened, what it means right now, and what employers and foreign workers should be watching closely in the coming weeks. Before I start, let me remind you that this channel is dedicated to provide you with immigration news updates and information. Make sure to subscribe to our channel. Also, hit the bell icon so you can be notified as soon as a new video is posted. Let's get started. What happened today? A federal judge in Massachusetts issued a significant ruling regarding H-1B program. The court invalidated the policy that required employers to pay an additional 100K fee when filing certain H-1B petitions. According to the court, the government exceeded its authority by imposing a fee that functioned more like a tax without authorization from Congress. As a result, the policy was vacated and is no longer in effect. Why is this important? Because unless another court intervenes, the USCIS should not require employees anywhere in the United States to pay the 100K fee. That is a major development for businesses that are unwilling to absorb such a significant additional cost. What fees apply now? For the moment, employers are back to the traditional H-1B filing structure. That means the H-1B registration fee remains in place. The standard filing fees continue to apply. Employers are not required to submit the additional 100K payment. For many businesses, especially smaller employers and educational institutions, this dramatically changes the financial calculation of hiring foreign talent. What about H-1B extensions and renewals? One important point, H-1B extensions and renewals were generally not subject to the 100K fee. As a result, this ruling does not significantly change those cases. The primary impact concerns new H-1B filings that would have otherwise triggered the additional fee. Can the government appeal? Absolutely. In fact, many observers expect an appeal to be filed quickly. The government may also ask a higher court to temporarily pause the ruling while the appeal is being considered. If a stay is granted, the USCIS could potentially resume collecting the fee during the appeals process. That means today's outcome may not necessarily be the final chapter. What should employers do now? Employers considering H-1B sponsorship should pay close attention to developments. While the current ruling removes the fee, the future court decisions could affect filing strategies. Companies should monitor updates closely, review hiring plans, coordinate with their immigration counsels, evaluate whether filing opportunity now makes strategic sense. Timing may become extremely important if litigation continues. What does this mean for foreign workers? For foreign professionals seeking H-1B sponsorship, this ruling may reopen opportunities that had become financially difficult for many employers. Some organizations delayed hiring decisions because of the dramatically increased costs. The removal of the fee may encourage additional sponsorship activity, particularly among smaller employers, startups, research institutions, and educational organizations. However, applicants should remember that the litigation is ongoing. The key takeaway is simple. As of today, the 100K H-1B fee has been struck down nationwide. Employers currently should not be required to pay the fee. However, appeals are expected and the legal landscape could change again. If your company is considering H-1B sponsorship or if you are a foreign professional evaluating employment opportunities in the United States, now is an excellent time to discuss your options with experienced immigration counsel. At Amir Law Firm, we are actively monitoring this policy and advising clients worldwide. If you have questions about H-1B visas, employment-based immigration, and firm labor certification or green card sponsorship, contact our office. For guidance, you can book a consultation at our website, www.amirlawfirm.com. Policies like this can shift rapidly. Stay informed. Subscribe for verified immigration updates from Amir Law Firm with clarity. Thank you for watching, and I will see you in my next video.